Recording in progress.
Good morning. Start my video. Doing a little microphone check and making sure the world is working when I do this presentation. So hopefully everything's working well. Without further ado, let me share a screen and let's get going. Today we're going to talk about medical legal and ethics and see what we could come up with. Here we, I hope, go. There we go. So, all right. Good. Good. So today we talk about medical legal and ethics. A very important part of our job. This because also could be a lot of the decisions we make in EMS are multi-million-dollar decisions. And when it comes to multi-million-dollar decisions, they can also be career-ending decisions we're making. So it's very important that we know what we're getting ourselves into when we talk about medical legal. So today's goals. If we can advance, there we go. Today's goals are all right. There we go. So we're going to be able to identify the scope of our practice. So as we identify that, we're going to explain the advance directives. We're going to explain the different types of consent. We're going to explain abandonment and identify the components of negligence. And explain the role of the EMT and the advance directives that we follow. So when we talk about what we can do, what is allowed, what we're taught to do, this falls under the scope of practice. So the scope of practice covers it outlines care you are able to provide as an EMT, because this is what your training covers. Usually defined by the state law. It's also defined by national curriculum and whatever we've collaborated to come up with. So when we talk about what gives us the ability to actually practice, the Medical Practice Act is state legislation. It is also on a federal legislation. Public health law is stating this information, and this defines the scope and role of all pre-hospital care workers. This is covered under Article 30. And when we talk about Article 30, we're also talking about Part 800 that covers the certification of advanced life support, first response services, and ambulance services. So it actually tells you literally how many Band-Aids should be in an ambulance. And this is what they strive to do. So when we talk about the scope of practice, this is actually defined by a medical director, and he further defines it down the line with each agency with protocols, which we do on a collaborative aspect, and we also do it in a regional aspect. The standing orders also, which are orders that we can do without verbal permission. It's a written order. So the legal issues that we're going to face in EMS is the different types, the different types of consent. So express consent is, yes, please take my blood pressure. Patient directly indicates consent. Yes, they want you to do that. So how can a patient indicate that they want consent? Just like I said, they're going to say, please take my blood pressure. In an emergency, patient must agree only to the general nature of treatment or at least not object to it. So if it's true emergency and you're like, sir, you're having chest pain, I would like to treat you. The patient's going to say, sure, you can treat me, go for it. Excuse me while I get a drink. Sorry about that. So moving forward, the patient is of legal age and they're of rational mind. And we'll talk about how you determine that they're of rational mind, and if they're competent versus do they have the capacity. So we'll cover that also. So informed consent. Informed is you've informed them, you've taught them. So patient must be aware of, meaning you told them that what the nature of their illness or injury is. So they need to know that. What the recommended treatments and associated risks would be with that. Any alternative treatments and associated other risks that might come with that. And the dangers and the consequences of them refusing care. So if you refuse care and you're having chest pain, this could be a heart attack. This heart attack could lead you to go into cardiac arrest, could lead to major disability. If these things happen, your life is either going to be over or over as you know it. When we start getting down the line of implied consent, so we've talked about expressed, informed. Now we're implied. Look at that. Let's go ahead. We'll make a change on that. Don't you worry. Implied consent. This incapable of making an informed decision. So maybe they're unconscious. Maybe they're under the influence so heavily that they cannot make an informed decision. So when we talk about implied consent, we need to determine a few things. This presumes unconsciousness or mentally impairment of a patient if they weren't in those states, they would consent to life-saving treatments if they were able to do so. So if they weren't unconscious and they were awake and they're looking straight at you and they're alert and in the right mind, they would say, yes, please treat me. Assume the patient would consent if they were conscious, just like I said. And if you think about some examples of implied consent, you go to a heroin overdose that they're unconscious, they're not breathing. Somebody that is falling down, can't walk, drunk, that is so drunk they can't even walk a straight line and they have no idea where they are. A dementia patient that thinks Nixon is still president. These are all things that come into play. And as we start getting in the patient assessment, we'll start talking more about how that comes into play with your interview and how you're going to determine if they have impairment of some sort, whether it be mental cognitive impairment because of a medical condition or an external source of impairment such as drugs or alcohol. All right, so examples of implied consent. So if you've watched more than one of my slideshows, Tiger Blood here, it might show up every once in a while in my slides. So this is a good example. There's an unconscious patient. There's a significantly altered mental status. Alcohol and drug intoxicated. This can be a sticky area because somebody that's intoxicated or under the influence of drugs could still be able to answer all of your questions, and they have the cognitive ability to know where they are, what time it is, who you are, who they are, who everybody else in the room is, or what is going on in their situation. They may be able to tell you all that stuff, and then if that's the situation, they may very well be able to say, don't touch me. But keep that in mind. And then we run into the sticky problem of minors without a parent. So a minor in New York State is under 18 years old. So once they're 18 years old, they are no longer a minor. And this goes back to the emancipation of minors too. So when we talk about emancipation of minors, we talk about they are legally able to make their own decisions. They have separated from the parents. People take for instance, a new mom at 16 years old, perhaps, she still is considered a minor. She might call herself emancipated. She can make decisions for her own child. However, she's still a minor. Lots of paperwork is involved for emancipation. So there has to be a legal process to make that happen. Just because somebody has become a parent does not make them emancipated. So, and then mentally incompetent adults. So we deal with a lot of group homes. You deal with a lot of those types of setting. We also deal with a lot of dementia patients, Alzheimer's patients, people that receive home care from their families. It is not uncommon for us to be called to a scene that has perhaps mom that's 92 years old that has wandered away from home. We don't know who mom is. We are called to the scene because mom has ended up at Dunkin' Donuts and has no idea where she is, wearing her pajamas and her slippers. She doesn't know how she got there. So a lot of times that happens. That happens. We need to do something with that, and we usually try tracking down. So last result, we take them to the hospital. And then consent for children and incompetent adults. When we talk about children and incompetent adult, we have to get consent for parent or guardian to take care of a child that does not have a life-threatening problem. So my child has a fever and they're at school and the nurse calls you because they want you to take them to the hospital. However, they haven't been able to contact a guardian or a parent, and you determine there's not a life threat. Can you take that child to the hospital? Probably not. News story: if the child has a life-threatening emergency and they can't find the parent or the guardian, we take them to the hospital, because the life threat that's there could potentially end this child's life. And this falls under the, I'm going to imply that if a parent was here, they would tell me to do everything they possibly could do for this child. And then also it goes back to incompetent adult. This child is a victim of, if you suspect victim of abuse and you fear that if you leave them at home, the abuse is going to continue and that child is going to be hurt worse, this is an issue we need to address. The child needs to be removed from the situation. That is a situation definitely involve law enforcement. Do it early. All right. And we talked about emancipation. So state regulations, New York State, 18 years old. Emancipation consists of legal process of lots and lots of paperwork to make that happen. Just because somebody's living state away from home does not make them emancipated. Now we start going down another sticky area, the area of involuntary consent. When we talk about involuntary consent, we are talking about taking somebody to the hospital against their wishes. When we do that, we say, who are those patients? Those patients are mentally ill, in a behavior crisis that could be developmentally delayed. So they are a risk to themselves. They are a risk to others. So your suicidal, your homicidal patients, they need care. They need mental health care. In our society, it's getting a little bit better, but it's an issue of lack of mental health care. One of the problems too is we can't force care upon people. So it's very common to have a patient that says, well, I don't take my medicines because they made me better and I'm all better now. And you're like, well, now you're back to square one because that's what the medicines were for. So they're now in a behavioral crisis. They're a person in conflict and a person in crisis. We need to take care of them and understand that they perhaps do not know what they're doing. If you're transporting somebody to the hospital and it took some effort to get them to go to the hospital, finally they agreed. And when they get to the hospital, you open the back door and they pull a gun in your face. That is not a rational thing for somebody to do. Obviously, there's a mental illness that might be involved with that. There's impairment that might be involved with that. So yes, scary situation for us. That's where we need to use our brains, and we need to learn from the experience of others, not to put ourselves in a situation of safety, of lack of safety. So, but this is a serious issue. So if it's a minor, or if it's a guardian, somebody that cares for a developmentally or a mentally ill patient person, they're going to obtain, if you have consent from the guardian, you're going to take them. This is not always possible, so that's where you have to go down the implied route. If a person is not able to make that decision for themselves and the guardian is not there, you might just have to do it for them. And that's where involve police. So now we start dealing with, what do we do with somebody that is absolutely refusing to go to the hospital, and everything in your power you've tried to get them to go, however, they're going to fight you. So now we have to deal with forcible restraint. Sometimes this is absolutely necessary with a combative patient, and we can legally do this. And when we do this, these are the guys, the law enforcement involve them. They're trained to do this. They spend a lot of time training to do this, where they're not going to permanently injure somebody, but they're also going to train so they don't injure themselves. So when we restrain somebody, we use soft restraints that are easy to untie or easy to release, even if you have to pull a pair of scissors out and cut them. So, but we have to do it safely. We have to, and you know what? It's okay to call a lot of friends and team up on somebody. It's not being mean. Do not lose your cool while this is going on. If a person's going in this situation, they will call you names. They will insult your mother. They will insult your children. But you know what? That means nothing coming from them. When they say that, you can't let it mean anything to you. Just do your job and remain calm and professional. And by goodness, by golly, don't tell somebody, calm down, because the opposite happens. All right. And then most of the time, I have gone into situations that are so out of control. Sometimes you can talk a patient down and say, everything's going to be okay. Don't say calm down, but can we verbally de-escalate this? If we can verbally de-escalate this, awesome. We should, because if we could avoid tying somebody down, it'd be great. All right, confidentiality. You guys are going to be out doing calls. You're going to be out for maybe the first time ever in an ambulance. And as you're out first time ever in an ambulance, you're going to look upon the situation you're in and you're like, oh my God, that was a cool call, perhaps. I'm like, oh my God, did you see that person? Oh, you know what? I literally saved somebody's life. You're going to want to talk about calls. I guarantee it. So then when you talk about that, we have to keep in mind the confidentiality of that patient. So in 1996, the feds actually came out and said, here's a law. This is the HIPAA law. This is the Health Information Portability and Accountability Act. It is a law. You can't share patients' information with other people that should not be involved in their care. So don't go home and tell your parents, and don't go home and tell your loved ones. Don't sit around the dinner table telling your friends and at the bar. We don't talk about those things. The patient's privacy is high on the priority list of things we're going to observe and try to maintain. So this safeguards against the confidentiality, and it also considers what is the protected health information, so PHI. You'll hear PHI referred to a lot in an ambulance. In an ambulance, when you are dealing with HIPAA, we will give information to the hospital because it's part of patient care. Our billing department will get information. The if we're doing a meetup with another ambulance, we could pass information on to continue that care. What we can't do is we can't pass it backwards. We're not going to do that. Also, you cannot help a police officer in an investigation by telling them something that happened in the back of your ambulance. So when you go to a violent crime and the patient spills the beans in the back of the ambulance to you as you say what happened, and they tell you all about it, and then you get to the hospital and a trooper comes up and says, hey, did they tell you anything in the back of the ambulance? And you can say, yes, of course they did. And they'll go, and then you should say, and you should give me a subpoena. I'd be more than happy to tell you. Don't do it. It has to be legally binding so you can actually give that information. So here we go. We can disclose this information for if the patient signs a release. You're not going to be dealing with that in the field. That's an after the fact thing that comes through the administration of the agency you're at. A subpoena, just like I said. Many different types of subpoena. I've been in court many times. Every time is with a subpoena order. Billing personnel. Obviously, we can't just bill somebody for a willy-nilly reason without saying what the heck happened and why were they in an ambulance. So billing needs to know this information. They make the world go round. All right, another sticky area, yes. When we talk medical legal stuff, it is sticky, sticky, sticky. So we talk about advanced directives. Advanced directives are going to state what the heck treatment does a patient want if they cannot answer or they can't make their own decisions. Maybe they're unconscious or maybe they're so sick and ill they can't talk. This is where this advanced directive comes in. So the main advanced directives you guys will see the most is a do not resuscitate order or a DNR. DNR can come in a state form that says New York State, do not resuscitate order. You do not see these much at all anymore. You do, however, see the MOLST form. And as you're looking at a MOLST form, it's going to have the patient's information, the provider's information, signatures of patient and family, or perhaps signature of a power of attorney if the patient isn't able to make those decisions anymore. And the doctor sign. This is stating what do they want done. So do not resuscitate means if I go into cardiac arrest, please let nature take its path. Just let me go. But it also may say, listen, I don't want you to do CPR. However, I want you to support my airway. Hopefully that'll get me to where I need to be. Or it might say comfort care only. So if a patient gets down, they're still alive, we're just going to keep them comfortable until nature takes its course. All right, so this gives us permission to not resuscitate. This is where it's difficult when we are a human being, because we do this job because we want to care for other human beings, and that's what we truly do. We care for other human beings, otherwise we have been doing this every day. So this might be an ethical conundrum for you, but you know what? We need to be able to do this. If somebody's in cardiac arrest and you do CPR and you get ROSC on them, most likely they're not going to be the same person if they even wake up. CPR is a horrible, horrible thing. If you do CPR on somebody and they wake up in your ambulance, that's awesome. That doesn't hardly ever happen. So it will, if you're good and you get on top of it immediately and you're there when it happens. However, the more time that goes by, the more that's not going to happen. So if somebody with a MOLST form and they're elderly, what kind of quality of life are they going to have if they even are able to wake up? If they can get off of life support and all that, are they even going to do it? What's the family going to have to go through? And that's what the thought process for these patients go into when they sign these do not resuscitate orders. So do not resuscitate does not mean that you don't treat. You'll go to a lot of nursing homes and you go to a lot of home care situations and a patient will be sick with like sepsis or something like that. These things are easy, these things we can reverse. We can give medications and we can give fluids, and a lot of these things are reversed. So we got to actually treat for what we're seeing. We don't want them to go into a situation where we have to resuscitate them. So our goal is to prevent that. And when it comes to other things, when we're down that line, if we could prevent them going into that situation where this MOLS form will actually kick in, that's great. So, and then you deal with healthcare proxies. Healthcare proxy is part of advanced directives, and this is a person that has been selected by the patient to be able to make medical decisions if the patient's not able to. So healthcare proxy. This is when you deal with healthcare proxy in the field, if they don't have this form with this form, and the healthcare proxy says, please don't do anything, call dad. Say, hey, I have a healthcare proxy on scene. I don't have a DNR order. Healthcare proxy says that this patient is terminal. They do not want us to start CPR in this patient. I am not going to take the responsibility for that, doctor. What do you want me to do? So when I say call dad, that means call medical control, call the medical direction, that we talked about in a previous slideshow. So medical direction's there for a reason. They may say, if you don't have a MOLST form, got to do what you got to do, bring them here. So then we'll work that cardiac arrest and do our best and see what we could do. So, all right. And dealing with advanced directives more, some patients have named surrogates to make decisions for them. That's where that proxy comes in. There you go. Living wills. This is another form. Please, in this state that I'm in, if this happens to me, please do not do this. Unfortunately, we can't accept these. They have to be official do not resuscitate orders. All right. Special situations we'll deal a lot. We'll deal with, if anybody of you actually know what road ID is. If you do anything outdoors, if you hike, if you bike, if you run, if you do anything outdoors sports wise, I do highly recommend that you do get one of these, because it helps responders hugely. Because on these road IDs, they actually have all of your information in your emergency contact. But now also they actually you could go to the road ID database and pull up your information and pull up all the medical history and everything else. In that medical history, you may see DNR orders and everything else that go along with that. So look for medical identification. This is going to be in the form of bracelets, necklaces, maybe even a card. On the phone, they have the emergency where we can access it and pull up your information on there. So in that, we'll see maybe a DNR order, allergies, medications, history, everything that goes with that. And very, very helpful. So if you go onto a scene and you're like, why is this patient unconscious? Look for medical alert identification of some sort, because I bet they might actually have one if they have a condition. So, all right, legal issues. This is one of the driest yet most important things of our job when it comes to what we say and what we do and how we act. We fall under the legalities of it. Again, multi-million-dollar lawsuits have happened. Life-changing and career-ending decisions have happened. Huge financial impacts on providers and agencies have happened. So looking at this information, we talk about the standards of care. When we talked a little bit about that before, but talking specifically about the standards of care, when we talk about it, this is the manner in which you must act or behave. So when you act or behave in this manner, if you're doing what you should be doing under that standard of care, that is what is expected of you. And when we're not licensed, we don't work under our own license, we work under certification. So that certification is given to us to say that we are practicing under a doctor's license. The doctor is overseeing this, and this is what the doctor has said that we can do. So they're established by the statutes of the state. So you'll see in New York State, which I do encourage you in New York State, unless you happen to have found this video through YouTube from Oregon. Welcome, Oregon, if that's the case. However, you're going to find it, whatever state you're in, the statutes. The statutes will be the protocols and everything else that's written. So in New York State, we do collaborative protocols. So if you were to happen to look for New York State collaborative protocols, you will find them. Also, we use an app called Muru, M-U-R-U. I highly recommend that you do download that, because it really will break those protocols down, and it's very, very smart app that works very well with that. So, and this comes to the standards that are on the professional and institutional standards of what's expected. So AHA CPR guidelines. So when we do that, so if you're in an EMT class and you're taking the CPR portion of the EMT class, like my EMT class just did yesterday and the day before, they will go through all of the didactic information online, and then they'll come and they demonstrated skills, which is something that we get right on top of. So, which is awesome. And then the textbooks that establish what we're doing. National Highway Traffic Safety Administration has oversight in a lot of the protocols and standards that we're doing, and also national curriculums that go along with that. So the Medical Practice Act, ding, 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 hint, hint. This may be a question one day. So this is determined by state legislature. It's also delivered on a collaborative aspect from a national legislature. And it has laws that define the practice of medicine. Laws that define the practice of medicine, and not just in EMS. So this is the standards of care in our profession, the standards of what we do and what is expected of us. This is in New York State. It's Article 30 of the Emergency Medical Services. And again, I talked a little bit about Part 800. Please look up New York State Article 30, or New York State DOH Article 30, and peruse through that. Tells you why we are what we are. So now let's talk about the liabilities we face because of the decisions that we're making. So remember, one decision could cost millions of dollars. When we talk about abandonment, when we go to take care of a patient, we are expected to take care of them, not look at them and leave. So when we talk about abandonment, this is a unilateral termination of care from an EMT without the patient's consent, without making provisions to continuing care. Okay, so when we talk about that, so if we go to help a patient off of the ground and don't ask them to go to the hospital, and they ended up having a broken hip, but you didn't assess them and you left them there, you abandon them. Maybe that patient actually wanted to go to the hospital but was afraid to ask. So that's part of our job. We have to do that, because if you don't do it, it could also lead to negligence. Negligence is a failure to provide the same care that a person with similar training would provide in the same or similar situation. So if I'm the EMT that went and cared for the patient that fell, that had hip pain, and I assessed them, I found the hip pain, I carefully moved them onto my stretcher and took them to the hospital, and as a paramedic, I treated them for pain or whatever else. That's the standard that we would expect. So the next week, another EMT would go to the same thing. They would pick the patient up and throw them back in their bed and be out the door. Wouldn't even write a chart of what that was going on. They could actually be found negligent because the person with similar training that from the first example is what is expected to happen. So the second person that threw them in bed and left didn't provide the care that they're trained to do. So, And also deviating from a standard of care resulting in injury to a patient. So if you want to do a cesarean section in the field, don't do that because you're not trained to do that. And there is no accepted standard of care in a pre-hospital environment to do that. So don't do that. That's pretty dramatic what we're looking at. All right, so now we're talking about negligence. When we're talking about more down the line of negligence, and then we need 4 elements to be present for this. So when we talk about the 4 elements, we got to have that duty to act. So when we have a duty to act, it means we are on the job. We're in our vehicles, we're on our job. We can't just pass that car accident and pretend like we didn't see it. We can't, if we're in getting something to eat at a convenience store and somebody passes out and drops to the floor in front of us, we can't just walk away. We have a duty to act. So when we don't act to that duty, we breach that duty. So we have breached our duty to act. And this behavior has caused damages. And the direct causation of the behavior also that causes that damages, but so much more. So there was a causation of this intentional duty, a breach of duty, because you didn't follow the duty to act. All right, so overlook stuff. When we overlook things, it starts in the morning when you're, or in the evening, depending if you work nights, the beginning of your shift. So we're gonna maintain that equipment, supplies, in the vehicle. So we have to check that vehicle to make sure everything's in there to take care of a patient. So if you have monitors and oxygen and all that stuff, make sure you have it. Make sure it's not empty. The batteries aren't dead. And when you're checking your vehicle, make sure there's fluids and gas in the vehicle. Make sure that if you, and then further down the line, perhaps an agency issue, if you have driven a vehicle and you found that you were having, the brakes were being strange and pulsating and grinding, and you reported it and nothing was done and that vehicle stayed on the road and they got in an accident, similar to what happened here. If that happened and you reported it, that is negligence on the aspect from the agency because you did report it. All right, guess I'm taking it down the line of here. I'm going to take 2 seconds on a break here because I got to plug my screen in because apparently it doesn't want to work.
Mississippi, we're a Category 5 hurricane.
Yes, yes.
So this has always been an issue with hurricanes taking that.
Okay, I'm very sorry about that. All right, back in business. Back in business. Stopping share for just a second. Sorry about that. Okay, now we are on it. You guys do, hopefully you see that. There. All right, so overlooked aspects of negligence. We have maintaining supplies and equipment. We talked about that, then driving negligently or recklessly. When it comes to litigation for EMS agencies, this is by far at the top of the game. So keep that in mind. So a couple examples: crash in Nashville, Tennessee, 36-year-old male firefighter died, 78-year-old female patient died, 51-year-old male paramedic in critical condition because of poor decisions behind the wheel. When you work for an agency, you go through driving training. In that driving training, they cover what you're supposed to do. And there's actually regimented driving trainings, for example, EVOC or CIVO, that are National Safety Council, for National Safety Traffic Council standards that put these things together for the agency. So you're actually certified as a driver under that. And take it seriously, take it very seriously. Bad habits occur, and then bad habits happen because of complacency, and it leads to accidents. So we want to keep each other safe. In Brooklyn, 4 people and 1 adult and 3 children. 4 people were killed, 1 adult and 3 children. And then because the ambulance sped through the intersection and struck another vehicle. Quite significant if you're looking at that damage to that vehicle. So the driver of this vehicle was charged with manslaughter because on 3 counts of manslaughter, because they were speeding through a red light on a non-emergency call that caused the crash that killed the children. So she was found. The police commission says she should not have been driving with their lights and sirens, and she should not have gone through the red light. So when it's determined by 911 what the priority of a call is in our area. And with that priority dispatch, that priority call determines if you should use lights and sirens or not. Ultimately, the safety and the safe operation of the vehicle ultimately comes to the operator of the vehicle. So whether it's a EMT, a first responder, an ambulance driver, yes, they still have those, or the paramedic, whoever is operating that vehicle is ultimately responsible for the safe operation of that vehicle. So, so this patient they were going at least 50 to 70 miles per hour in a 30-mile-per-hour zone. Huge. 19-year-old convicted of manslaughter, 19 years old. If you're watching this, 19 years old. Are you 19 years old? Are you in your early 20s? Are you in your late 20s? Are you in your 40s or 50s? This can be life-changing. Life-changing. This could potentially, because you injured yourself, could be life and health changing. All right, so she got 1 year in prison, and it cost her, I think that was a $600,000 bill on that. So, all right, now further along, assault and battery. Yes, we deal with assault and battery towards us as EMS providers. However, we don't want to be on the causation end of that. So assault is the unlawfully placing a person in fear of bodily harm. So you haven't actually committed the act. We're saying we're going to restrain you. If you don't behave, we're going to restrain you. We're going to put these restraints on. All right. Then battery is unlawfully touching a person. This is providing care without consent or transporting them without their consent. You forcibly restrain them and you actually went through the act of restraint, and it wasn't lawful because they weren't a hazard to themselves and everything else. Because remember what we talked about using when we have to restrain somebody, what goes into that. But when it comes to providing care without consent, if somebody tells you not to do something, I don't want an IV in my world as a paramedic. I don't want an IV. And you say, well, your IV will do this for you. And they say, you're not doing an IV. And guess what? Don't do an IV. It's okay. And that goes for transport to the hospital and everything else. Because if you transport somebody against their will, you could be looked at as kidnapping. So seizing, confining, abducting, or carrying away by force. This is the definition of kidnapping. So what we're going to do, transporting somebody against their will. And this is somebody that is cognitively and not impaired and is able to make that decision. False imprisonment charge, more likely defined as unauthorized confinement of a person. So, all right, now we're starting to talk about documentation, things you write down. When we write things down, we have to look at the communication that goes into false. If you document false information that will damage a person's reputation, that is defamation. There's two types. So libel, if you actually write it down, and slander, if you speak it. So rumor is a bad thing. Do not spread rumors. A lot of rumors come from fact. However, once the little tiny bit of fact, it just gets this big snowball effect. And you know what? A lot of time, most of the time, they're mean, and it could be slanderous towards a person, and defamation if they're writing that information down. So, so remember, just to keep them straight: library, libel, read and write, got it? And then slander, said, spoken, or oral. All right. Talking about defamation, we could actually do that in false statements on our run reports. This is when we talk about false statements, we're talking about opinions. We're talking about documenting something that didn't happen, and you're actually lying on that. Inappropriate comments made during conversations, so verbally, or you're writing it. And so when you're writing a run report, it should be accurate, relevant, and factual. Accurate, relevant, and factual. There's many different formats you can do, but it's very important that you're thorough and accurate with avoiding your opinions and predictions. We got to leave those out of there. So, all right, talking about the Good Samaritan law. This covers us when we're not wearing the uniform. This covers us when we are driving down the road or shopping at Wegmans with our family or out to dinner. So when we look at the Good Samaritan law, this is if you reasonably help another person, you will not be held liable for an error or omission. Okay? So meaning that if you actually provide care to somebody and an error happens, or you do not provide care for somebody and turn a blind eye, you're covered under this because you don't have a duty to act because you're not on the job. So, but to be a good Samaritan, these actions have to be met. If you go into a scene and you actually provide care for somebody, actions that need to be met. So you have to have done it in good faith, without exception of compensation. So you didn't go in there, hey, I'll help you breathe if you pay me $50. And it has to be within your scope of training. So if you, again, go back out and you're like, oh my gosh, that baby has to come out, and you do a cesarean section on somebody. Maybe you watched a video how to do it. Right on. It's not within your scope of training. Yes, I bring up that because there was years ago, I worked with a paramedic he was like, we should be able to do that in the field. That would be so cool. And I was like, dude, you're crazy. Anyway, I digress. But you did not act in a grossly negligent manner. Grossly, it's when you intentionally did something in a negligent manner. There you go, gross negligent. I conduct that constitutes willful or reckless disregard. So it's willful. You did this on purpose. And it's just reckless what you did. So records and reports, talking more about them, what needs to go in there. This is an important, when you document what we're doing, we're taking care of patients. When we're talking about taking care of patients, we're writing this information down, and it's a legal representation of what we've done. So the courts will take things into consideration. If the action is not recorded, it is not performed. So when we have an action that's not recorded and it's not performed, that's one thing. However, don't lie and say you did something when you didn't do it, because if that was found to be the case that is not in the situation, you are lying on a legal document, and that's horrible. Don't do that. So, and then, you know what? If you have bad grammar, if you have poor spelling, you need to work on that. It's very important that we have tidy reports with good grammar and good spelling that really shows of the care you give. Because incomplete and untidy reports show in the jury's eyes that you're sloppy, unorganized, and a bad EMT. It's just how it is. So evidence of poor emergency medical care, that report will do. All right. So now we're going to talk about refusal of care. We take all these legalities in aspect. We talk about refusals of care. So we go often to the quote unquote lift assist. If you get stuck, go down the pathway that you're stuck in the, oh, we're going to a lift assist, and you only look at it as that it's a lift assist, you're setting yourself up for failure, and you're setting yourself up for potentially lawsuit and everything else that comes with it. So when you go to those things, it's a fall. So think about how something happened when it comes to patients refusing. Everybody has the right to make their own decisions when it comes to their care. That includes refusing care. So when we talk about it, a patient has a right to refuse. You have the right to refuse to not go to the hospital or not be treated. So, but they have to be conscious, they have to be alert, they have to be adults with decision-making capacity. So if it's a minor and mom's saying, start an IV on him because you need to do that treatment that you just told her about, and the minor's saying, I'm not doing that, mom has the last say. Because it's the right thing to do, we also will hop on board with that. And you know what? When a push comes to shove in the end, make sure you work your way through it by talking. That's what I'm talking about. So conscious, alert adults with decision-making capacity. They have the right to refuse treatment, but we need to determine if there's impairment involved, we might say, no, you have to go to the hospital, but we have to determine how in-depth that impairment is. If you've started a treatment, they can withdraw from that at any time. So if you have a respiratory distress patient that you put a non-rebreather on and they don't like it and they rip it off, you could try to educate them. But if they end up saying, you are not putting that back on me, guess what you're not doing? Don't do it. So simple as that. This was a big thing when we had backboards. Get me off this backboard, it hurts. Well, you know what? It does hurt because it's been proven that prolonged use time on a backboard will cause injury. So keep that in mind. If they're conscious and alert and they're refusing and they want to withdraw from treatment or not let you do treatment, they can still do this, even if the end result is death or serious injury. As soon as somebody becomes unconscious, guess what? You're back to implied consent. Got to do what you got to do. All right. So when we talk about the burden on the EMT to clarify the need for treatment, the burden is on you. And that goes back to documenting the need for that, the risks, the consequences, everything that comes along with that. So everybody has the right to refuse treatment if they are mentally capable of doing that. So before we leave the scene where a patient, the parent or caregiver has refused we have to encourage them several times. You know, in the world, they say at least twice, several times. Encourage them to allow you to care for them or to transport them. We're here. Let us take you now because this is what this could be. This is going to happen again. This is what it could lead to. Make sure they know those things. So make sure they are fully aware of the risks and the consequences that go with it. And then ask them to sign a refusal. They have to be able to sign that refusal. Well, they don't physically have to be able to because some people physically are not able to. They have to be cognizant enough, and if they have their power of attorney, their proxy, do that, but also get a witness that that's happening if you can. And then document all the refusals you do. So every time you talk to a patient constitutes a refusal, a chart, you're getting information. Go back to HIPAA. Every time we talk to anybody in the medical field, they are covered under that. So if they fall under that, you need to document. And there's documentation that will be involved with that. All right, now we talk documentation, EDA liability prevention. We've said that already. No all assessment findings. Really, this is a really entailed documentation. We're doing this and attempts to persuade patient to accept care. It's literally spell it out. You have to spell it out. It is harder to write a refusal than it is to write patient care transport. So, and then sign it and document attempts to convince patient to go to the hospital. This includes, I tried to convince them to go. And then also I said, hey, if this continues, you've got to go to the hospital, please call 911. Make sure that they know they can call 911 back. I'm going to do other options too. Say, let's call your doctor. Let's call your family. Who else can I call to help me convince you to go to the hospital? Risk and consequences that we talked about. So document your conversation in detail. So let's talk about this 68-year-old injury from a fall. Here's a good case for you. So history of present illness. You'll see HPI as we're going on. Patient fell on the kitchen floor. The family carried to the bedroom. Patient told the family not to call 911. The daughter meets you at the door saying the mother is not competent and she has a durable power of attorney. Okay, that's great. Patient, she says the mother has hallucinations. She has Alzheimer's and paranoia after a stroke. She insists that you take the patient to the hospital. So think to yourself, does all of these, just because she has a durable power of attorney, and she says her mom has hallucinations, Alzheimer's, paranoia after a stroke, and she also says that she is not competent. Does she have the ability, do you have the ability to actually determine that? So further, you talk to the patient, she complains of hip pain. She does not permit you to examine the start. But she tells you the whole thing that happened. She slipped on the floor and fell, tells you her name, tells you where location. She's able to tell you who the president is. And you know what? As you get older and you go day-to-day routine where you don't go anywhere, she maybe forgot what month it was. That's okay. But after the third attempt, she was able to identify the month. And then she refuses transport or further examination. Okay, I'm not going. So what you guys find, because she finally allows you to do a visual exam of the leg and blood pressure, you see no visible rotation, shortening, or deformity. That's all you're able to do. Vitals are this, 92, so that's not too bad. Blood pressure is 142/88, pretty good. Respirations are 18 and regular. Those are good too. No life threat staring you in the face. Can she refuse? Think about that. Can she refuse? If she does refuse, what then? So you attempt unsuccessfully to contact a personal physician. Online medical controls says you can't transport her against her will because she has capacities, and the police actually support that also. They can't do productive custody for her because she has capacity, because she was able to answer all those questions. And the officer knows the patient and try to talk into him and convincing him. They can't convince him to go either. So the next day, finally, her children take her to the ER. She's diagnosed with a hip fracture. She has to have surgery to repair it. At the hospital, while she's admitted, she refuses O2. She refuses traction for the hip. She refuses to eat. She gets pneumonia and dies 1 week later. So the end result of all of this is she died a week later. But in the hospital, she refused all the care also. So the family tries to sue the crew, and they were unsuccessful because the crew was able to identify, was this patient able to go or not able to go? And they did everything in their power to get them to go, but they also tried to utilize medical control and police, and obviously family was already there talking till they're blue in the face. Did the woman need to go? Absolutely. The woman absolutely needed to go. However, she showed capacity to make those decisions of whether she's going to go or not go. So there we go. So the best protection against our liability is the training that you're receiving. And take your training seriously and keep up to date with continuing training. Competent patient care. Continue with compassion, because compassion will lead to competency in patient care, because you will take the extra step to really assess and take the time to deliver care to somebody that needs it. And then thorough documentation of the competent care that you gave. Talk about everything that you talked about. The family said this. The patient said this. I saw this. I did this. I treated with this. Very thorough. Patient refused. Patient understands that they may have a hip fracture. If the hip fracture is significant, this could result in disability. If it's left untreated, this could result into serious illness or death. They need to understand the risk and consequences, and you need to document that. Rule number 1 of EMS. If somebody's screaming and hollering at you, it's okay. That's their right. They don't know you. They have no beef against you. They're just acting out. Number 1 rule of EMS, be nice. Just be nice. Don't let people get under your skin because they're trying to get under your skin. Don't let it happen. Just be nice. And just listen. Listen to the patient, listen to the family, hear the whole story. And be nice. All right. So you guys, as you go through class, we'll do a separate aspect when it comes to mandated reporting, because there is an obligation that we have to do that, and the mandated reporting presentations and information that you can get on the state level is significantly better than what I can give you in here. So that's why it's going to be mandated for you to do mandated reporting training. See what I did there? So this is a reporting obligation. So elderly abuse, child abuse, neglect, everything else that comes along with it. There's every state, every region, every locality has a reporting process. Most of them are a phone number you call, make the report, and go from there. But there's also forms that we fill out for that information and follow up that we do it. Follow up is huge, because I don't know if you guys haven't been around, if you've been around more than a day, you notice that we had COVID, and what happened during COVID is staffing went to the wayside. And a lot of times it takes us to be the proponent for the patient to really do good follow-up to make sure these things are following through. So follow up, mandated reporting, because you'll get, if you call, I know in our area, if you call to do a report and it's off hours, they'll take your report, and then a couple days later, social worker or caseworker will actually call you and get further information if they need it. All right, so now we talk about ethics. And then, ethics, this also falls under the aspect of if we let somebody die or don't die. But ethics is the philosophy of right and wrong, moral duties, ideal professional behavior. So when we talk about the philosophy of right and wrong, in our culture, right and wrong is one thing. In another culture, it may be totally different. So it goes back to the moral duties and professional behavior. So our culture is EMS. And this is, when we give EMS, our culture is a culture of caring, and a culture of giving, and a culture of treating, and a culture of being nice, because that's what we need to do. So that's ethics. Morality, this is the code of conduct affecting character, conduct, and conscience. Morals, basically. So what is our morality that affects that? So that's how you're going to act is caused by your morals. So, and then the bioethics. This specifically addresses issues that arise in the practice of healthcare. All right, and our ethical responsibilities when it comes to be honest. Be honest. Oh, number one on there, be nice. Don't forget that part. But be honest. Keep accurate records. All right. So if you ever are called to court, you get a subpoena, you can end up in court as a witness. You could end up in a court as a defendant. And you can also, one more on there, you can actually end up in there as like a professional witness too. So you're going in there because you're an EMT, you're a professional EMT, and you may be going to saying, hey, in your standard of care, in your job, is it normal to do this? And you will, as a professional witness, you would actually might state that. So when you go to a court, it may be criminal or it may be civil, depends on which pathway they're going down. But be truthful, don't omit, make sure you tell them the whole story. But if you're getting that, if you're ever called to testify, you have to notify the service director. So if you're doing a ride out and you have to go testify, the service operations director, executive director needs to be notified that that's happening. Also, if you're happening in a class that you're in, an EMT class, make sure that they know about it too, because you may need legal counsel. And a lot of time that stuff might be provided for you unless you are completely criminally negligent, and that might be all on you. So, but as a witness, remain neutral. Remain neutral. Remain neutral means don't put your thoughts, don't put your opinions into it. Keep it factual. You have to be able to review the run report before you go to court. So you have a little bit of preparation before you go in there. So, all right. That's court. Court's fun. Says no one ever. Actually, if you've ever been on jury duty, it's very interesting. And don't be nervous if you get there, be excited, because it's actually kind of cool. So, all right, physical signs of death. So in our jobs, we have the ability to pronounce somebody dead under certain circumstances. So under those circumstances, I'm going to go through a few of them, and I have to warn you, some of these images can be very graphic. So when we talk, I would prefer you are exposed to the graphic images in a classroom situation that is controlled for the first time, opposed to out in somebody's home where these things have happened, where it's not controlled. Because when you have that, you're also going to have emotions, you're going to have smells, you're going to have all the other sensations that go along with what you're experiencing. This is just a visual experience. So I'll apologize now, but I think it's very necessary that you do see this now, opposed to when you're trying to do the job. So dependent lividity. Dependent lividity is blood settling. After our heart stop and the blood's not pumping anymore, obviously blood is going to settle in the lowest points of the body because of gravity. That's how gravity works. So once the blood settles, it starts to coagulate. Once it coagulates, it turns dark. So when we see the low portions of a body that is sitting on a surface, expected if you were to roll them on the side like they did with this patient, they're expect to see darkening of those areas. That's where the blood is pooled. All right. Rigor mortis. Rigor mortis is after a certain time after somebody dies, it is the body joints will stiffen. And this is determined on temperature, conditions, humidity, everything, how fast this happens. So if you're in Arizona and in the middle of summer, could be different than being in Memphis, Tennessee in the middle of summer, how quick this will happen. Different worlds. So rigor mortis depends on the area where they were living at the time that this happened, or not living, when they fell or when they died, what was the position they're in. They may very well be in a sitting position when this is going. So rigor mortis, if you ever see rigor mortis, one of the things we need to determine before we start CPR is there signs of obvious death. Rigor mortis is not one of those signs that goes through the entire body at a flip of a switch. It progresses. Usually it starts at the jaw and the neck. So if you go down to open an airway in a patient with rigor mortis and you can't, or in a cardiac arrest and you can't open an airway, think rigor mortis. Next step you should do is look for dependent lividity, because that's also not obvious because it's on the low portion of the body. So if you have this patient that is just having stiffness in the jaw and you can't move her head, roll her over a little bit to see if she has any dependent lividity, because that dependent lividity will happen quicker than the rigor mortis. So this is very graphic. So obvious mortal wound, if somebody's missing a detrimental part of their head, or they're missing body parts, being like a heart, they can't live without those things. So this is obvious. Do not do anything with these. These people are dead. They're not coming back from this, and don't even try. So, all right. And then after the fact, the putrefaction and the decomposition, when you see these patients, obviously you're not going to be able to do. Usually you can diagnose these people with your nose before you even get to them, but just by going into a building. It's a very distinct smell of decomp. And again, this determines, when this happens, is also determinant on the conditions of the ambient temperature, the humidity, and where you're at, how fast that will happen. And whenever there's dying or dead tissue, expect bugs. Flies, always, always, always. So if you see flies, expect maggots. So funny story, not funny, but they actually use maggots in a medicinal sense that are grown in a lab setting for wound debridement. And they do a very good job of wound debridement. So because they basically eat dead tissue. So, all right. So the medical examiner cases we have, they're going to be notified in cases of dead on arrival, dead on scene. So you get there and they're already dead. It was unwitnessed, and they can't say this is what the cause was because it was unwitnessed. So an individual that dies without previous medical care, say we don't really know what a cause could be. I went up to check on him and found him dead in bed in that morning, but you know what? He doesn't see a doctor or whatever. We're going to get the medical examiner is going to be involved in that because we need to know why. Suicides, obviously, because that's going to be under the circumstances of what is obvious might not be the cause. And violent deaths, shooting, stabbing, so on and so forth. Suspicious criminal activity, or I found there was a door was kicked in and I found this patient dead on the floor. No obvious injuries to the patient. I don't know why. What is the real story? So suspicious. So if we go into these situations, consider them a crime scene. And when we deal with crime scenes, remember that the crime scene, you got to look at it as a sterile area. We don't want to move a bunch of stuff around. We don't want to have a ton of people in on these situations. We want to minimize our impact on that scene because it's going to be investigated, and everything where you find it should be left. So if you get on these scenes, obviously our priority care is going to be the patient. Sometimes the best thing to do is throw a tourniquet on somebody, get them outside. All right. And obviously your priority, number one, is your own safety and your crew's safety. So don't enter until the cops say it's okay. We stage, you know, stage around the corner out of sight in a nice well-lit area. Remain alert for evidence. So if you walk in and you see an unconscious person sitting on the floor and you see a hypodermic needle sitting next to him, do not put your equipment on top of the hypodermic needle. If the hypodermic needle is in an area that is going to potentially injure you, move that, but remember where it came from because you need to tell the cops. Even better, if the cops are there, there's a hypodermic needle, I need to move it. And it'll be like, go for it, because they knew where it was. So, and then obviously any violent situation that you're cleared to go into always has a potential for escalating again. So be aware. So be observant, communicate with the police, minimize the impact on the scene like we talked about, and remember what you touch. All right, documenting it. do not put your opinions. We've talked about, I said this several times, don't put your opinions in your documentation. Be objective and factual. What I saw, this is exactly what I saw. And if somebody says words to you and they say something to you, quote it. So-and-so stabbed me, quote it. All right, quick review. But before we do that, let's watch a video. There's consequences to when we make poor decisions when it comes to the legalities of it.
We have new details tonight on 2 EMS workers charged with murder. They appeared physically in the courtroom for the first time today. The 2 are accused of killing Earl Moore Jr. after they strapped him to a cot face down. The autopsy found Moore Jr. died of asphyxia. Our Capitol Bureau Chief Cole Hankey is live in Springfield for us tonight. Cole, what new information did we learn today?
Well, today's hearing was supposed to be just about finding probable cause that any crime was committed, so this case could go to trial. But we ended up finding out some key new details about the Illinois State Police's investigation into this case. On Friday, a Sangamon County judge found there was enough probable cause to say Peggy Finley and Peter Cadigan need to go to trial over the death of Earl Moore Jr. The 2 are being charged with first-degree murder. In mid-December, they transported Moore Jr. to the hospital. Today, they sat in the courtroom as State's Attorney Dan Wright replayed the body cam footage from that night. In phone records acquired by the state police, Finley sent text messages to an undisclosed person after Moore Jr. was pronounced dead at the hospital. The sergeant said in those texts, Finley said she screwed up by not flipping Moore Jr. over, and that she said she took full responsibility. State Attorney Dan Wright revealed the phone call Finley made on the way to the emergency room as well. On that phone call, Finley said she was not taking vitals.
I'm not necessarily taking vitals because I'm not gonna poke the bear.
The state police sergeant also noted several instances where Finley and Cadigan contradicted their own statements. Finley told state police she took Moore Jr.'s vitals, but the hospital admitting him said no vitals were provided. Cadigan told police he had never received training about positional asphyxia, which was one of the causes of death for Earl Moore Jr. But the ISP investigation found Cadigan took 2 training courses on the subject in the past year, most recently in July. Cadigan and Finley's attorneys argued that while the state evidence might result in a criminal conviction, it won't be for first-degree murder.
We'll go on the record, and I don't ever do this, they will never convict him of first-degree murder. Never.
Why do you say that?
It's not there, simply not there.
Now, both defendants pled not guilty to those first-degree murder charges, and their defense attorneys are also arguing that their bond should be reduced. Both Finley and Cadigan are being held on $1 million bonds. Their defense attorneys want that to be lowered to $100,000 bonds, which would mean they would get out on $10,000 bail. Reporting in Springfield, I'm Cole Hankey, WCI3, your local news leader.
All right, Cole, thank you.
I am asking for every
Oh, boy.
patriot watching this video.
So consequences for our behavior. First-degree murder for those 2. That's intentional, premeditated murder that they're bringing those guys up on because of something that they shouldn't have done. As you watch the video, that was significant. They manhandled that patient horribly, placing them face down. If you spend more than a day watching the news, you know that this actually caused positional asphyxia, and you don't do that. So here's my thing to you. If you restrain somebody, they go on their back. They go with soft restraints. They go with soft restraints that you could easily remove. If a police officer has handcuffed them and they handcuff them to your stretcher, that police officer is riding to the hospital in the ambulance with you, so they can undo those seatbelts. Anyway, I digress. So let's talk about a couple things. You're arriving at a scene of an elderly lady complaining of chest pain and assessing her. She holds her arm out for you to take her blood pressure. This is an example of what? If you said express consent, you are correct. Which of the following is an example of abandonment? If you said an EMR is transferred patient care from an AEMT, you are correct. That means the AEMT transferred care to an EMR, which does not have the ability to transport patients in an ambulance because they're only a responder. The unauthorized confinement of a person is called what? If you said false imprisonment, you are right. Failure of an EMT to provide the same care of another EMT with the same training is called, you said negligence. You are correct. An 8-year-old boy was struck by a car, is unconscious, and is bleeding from the mouth. A police officer tells you that he is unable to contact the child's parents. You should, if you said A, you are correct. Continue to treat that child. He is in an unstable condition. An advance directive is, if you said C, you are correct. Which of the following patients is competent and can legally refuse EMS care? Sorry about that. If you said C, you are correct. You're treating a patient with an apparent emotional crisis. After the patient refused treatment, you tell him that you will call the police and have him restrained if he does not give you consent. Your action in this case is an example of one more on there should be E, being a gigantic jerk. Don't be a gigantic jerk. If you said A, you are correct. An EMT has a legal duty to act if he or she is you said B, you are correct. Which of the following statements about records is false? If you said D, you are right. The collective set of rules and duties that define the role of an EMT is if you said A, you are right. The law that allows an EMT to practice is if you said D, you are right. What is the state legislation that defines the scope and role of all pre-hospital workers? The scope of practice. This is our role. And that's defined under the Medical Practice Act. So you can treat an unconscious adult because of they're unconscious. So you could treat them because of D, implied consent. You would assume if they were alert, they would say, help me. Which of the following is not a component of negligence? If you said D, that's right. Which of the following advance directives can an EMT accept? A DNR. We can accept the DNR, so B. To whom can an EMT provide patient information? D, that's the right one. The right of a patient to make decisions concerning his or her health is called B, patient autonomy. Autonomy means that they have the ability to make decisions for themselves. Basically, the ability to make a self-decision. There you go. What is the best protection against lawsuits in a refusal of care case? If you said A, absolutely. Which of the following is unlawfully placing a person in fear of immediate bodily harm? D it is. All right. So if you have questions, obviously this is a recording. If you do have questions, and I do invite you to ask me through this site, or perhaps your EMT instructors or your mentor, whoever you may have. Today, I thank you for coming, and again, good luck in your future endeavors in EMS. Have a great day.